Welcome to this episode of Courtside Commentary, where we'll be talking about two recent cases that could and arguably should have been important non-delegation decisions. We'll talk about the cases themselves, as well as what their outcomes portend for the future of the non-delegation doctrine. My name is Mark Chenoweth. I'm the president of the New Civil Liberties Alliance. Here to discuss these two cases with me is the attorney who led our efforts in both of them, NCLA General Counsel Zhonette Brown. Zhonette, welcome to Courtside Commentary.
Thank you. It's good to be here.
Zhonette, to begin with, what is the FCC v. Consumers Research case about?
Well, on the factual side, it's about the Universal Service Fund. The FCC charges a Universal Service Fund to pay for low-income rural subscribers, hospitals, elementary schools, libraries. It's a form of subsidy. Anyone who gets a telecommunications bill will see Universal Service Fund fee on their bill. On the legal side, the question was whether or not the FCC, the statute that allows the FCC to put that on your bill, is actually constitutional.
So why did the court take this case?
The court will oftentimes take a case where there's been a circuit split, and here there had been a circuit split. The 11th Circuit, the 6th Circuit, and initially the 5th Circuit panel found that the Universal Service Fund, the fee, was constitutional. But the 5th Circuit then took it en banc and held the other way. So the Supreme Court took the case to resolve that split among the circuits because obviously it's an ongoing program. It hits your bill every month. It gets recalculated every quarter, and so it's an ongoing case in controversy.
Zhonette, what did the 5th Circuit hold below, and what were the arguments coming into the Supreme Court?
Sure. The 5th Circuit basically engaged in what the Supreme Court called a combination theory. So there are actually two issues of delegation. What we call here the legal issue is non-delegation. The non-delegation doctrine essentially polices the vesting clause in the Constitution that says all legislative powers reside in Congress. And so it is a violation of the non-delegation doctrine if Congress gives away that power to the executive. There is a related, or there's a debate about whether there is a related non-delegation doctrine for private entities when an agency gives power to a private entity. What the 5th Circuit held essentially was the delegation from Congress to the FCC was questionable. The delegation that the FCC then later made to an administrator to help calculate the Universal Service Fund fee was questionable, and the two of them together in combination violated the Constitution.
And what did the Supreme Court think of that kind of combination theory?
The Supreme Court was not a fan of that combination theory, and the Supreme Court found no violation under either side. So first, the Supreme Court said what Congress did in the Universal Service Fund statute and that entire regime was constitutional, and then the FCC acted constitutionally when it enabled the administrator to have a deep involvement in calculating the fee that shows up on people's bills.
And so what's the argument as to why the statute didn't provide enough guidance to the agency?
If you read the statute on the surface level, it doesn't seem to. So let's talk about the non-delegation doctrine. The idea is that to prevent an agency from exercising legislative power, a statute has to give that agency certain constraints, certain limitations, what's called simplistically now the intelligible principle doctrine or intelligible principle standard. The idea is that Congress has to set the policy and the boundaries for what the agency is able to do.
So the agency is free to act within certain boundaries, but there needs to be some line that's clear that the agency can't act beyond.
Exactly, or at least clear enough for the court to be able to determine that the agency has gone too far.
Has exceeded the bounds of what Congress delegated it the authority to do.
Exactly. Has essentially violated the will of Congress because a statute is an act of will that only a legislative body can promulgate. And so if Congress doesn't provide those boundaries, then the power that is granted to the executive is legislative power. And it's a misnomer, actually, to call it non-delegation, because Congress can't just get that power back. They have to pass another statute, override a veto. But in law, it's colloquially known as the non-delegation doctrine. We call it vested powers.
So, Zhonette, NCLA submitted an amicus brief in this case. What were the arguments that we were putting forward?
Well, we had hoped, and I think many people had hoped when the Supreme Court took this case, that it would revisit and strengthen the non-delegation doctrine, because it has lapsed.
Bring it back from the dead, maybe.
Yeah, well, not quite, but almost. And
it's
some
moribund.
courts,
Yeah.
yes, some courts have flat out said it's nearly a dead letter, or it is a dead letter not properly interred. So we were hoping that the Supreme Court would bring strength back to the non-delegation doctrine, because oddly, the non-delegation doctrine has actually waned as the administrative power has waxed, and that's backwards. It shouldn't be that way.
So what was the intelligible principle that was supposedly at stake here, and was it enough?
I don't think it was enough, but what the Supreme Court seized on, because what was really at issue, what Consumers Research put at issue, was the amount that the FCC could charge under the Universal Service Fund to support it. And what they argued was that it's equivalent to a tax, and because it's equivalent to a tax, there had to be a definitive limit on what could be charged, a specific amount, a specific tax rate, something along those lines. The court rejected that argument.
What did the court say the limit is?
Well, the court picked up on this language from the statute that says that the FCC can charge what is sufficient to support the Universal Service Fund program. And then the court dug further into the statute and said there are requirements for something to be in a Universal Service Fund program, has to be essential, etc. There are principles that determine what can be part of the Universal Service Fund. But the reality is the base statute, Congress itself, when it created this statute, said universal service, essentially, is what the FCC says it is. And so that's the problem. That is a lot of leeway. But the court took all of the pieces, and I think it's important to know that the court's interpretation of the statute here differs from what circuit courts below had found and how the statute had been interpreted before. So, as I said, the statute has guidance, requirements, if you will, and then principles. And historically, when there have been legal battles over whether or not the FCC has properly calculated the Universal Service Fund, there have been the question of whether or not, the FCC is prioritizing the right issues. And essentially, the courts have said, look, there are 6 principles at issue here, one in the service fund. One of the principles allows the FCC to add its own principles, and the FCC can balance when those principles conflict. The FCC has the power to decide what's important and what's not. The Supreme Court didn't read it that way, and that's how they got to that finding an intelligible principle.
So a little bit like what the Supreme Court did in the Gundy decision, another case that we had hoped might have non-delegation implications. They read the statute to be a little more strict than maybe one would read it on the surface.
Not just more strict than one would read it on the surface, but more strict than the agency had read it for the last few decades, and more strict than lower courts had read it.
In order to uphold it, they read it more strictly.
Yes, they did.
Yeah.
And very much like Gundy.
And so what was NCLA's solution? What were we hoping the court would do with this statute?
Yeah, we wanted the court to go back to old iterations of the non-delegation doctrine. It didn't have to plow new ground here, but if you go back to, there's a case called Op Cotton Mill, Yakis, those cases essentially said that Congress has to not only set a policy, not only set boundaries, but there has to be a standard, a rule of action in the statute for the court and the public to be able to tell whether the agency's action was consistent with the will of Congress when it created the statute.
So there has to be enough of a standard in the statute to ascertain what the will of Congress actually is.
Exactly. And a directional, which seems like is in the Universal Service Fund, do advanced technology, do evolving levels of technology. A directional like that is not a standard.
Zhonette, were there any issues raised by other amicus briefs that we should talk about?
Sure. Well, there is a lot of people were hoping that the Supreme Court would change its approach to the non-delegation doctrine. So there were various suggestions on how that could or should happen. People supporting the FCC obviously felt that the intelligible principle was working just fine the way that it was. People who were more aligned with our view of the importance of constitutional restraints took different approaches, but there was somewhat of a coalescence around the idea that there needs to be a more strict standard on Congress when it's transferring power on important subjects, things that have more heft and weight and impact in the world.
Well, one would think that taxation is a core power of the legislature.
Yes, one would think. There is a prior case, however, where the Supreme Court had rejected the idea that, for example, core powers, specifically taxing power, would require a different delegation standard, the Skinner case. And the court in the FCC case went back and back to that Skinner case and said, we've already addressed this issue, number one. And number two, it's just not workable because what's the difference between a tax and a fee? And it's a morass as to whether or not any particular revenue-raising effort by the government is a tax, a fee, or something else. And so we couldn't create a new standard for taxes without throwing a lot into question.
So what did the Supreme Court ultimately rule here?
The Supreme Court ultimately ruled that the Universal Service Fund statute provided sufficient intelligible principle when you read it in context with all of its provisions and with the history of the Universal Service Fund program. The court starts off by noting that the Universal Service Fund idea is as old as the FCC. And so it has had different iterations over the last century, but it has always been a core part of the FCC mission. And so looking to that history, looking to the statute, to the requirements, to the principles, the court said the statute limits the recipients, limits the program, limits the services that can be provided, and requires that the funding be sufficient, which the court found is not only a floor to how much the commission can collect, but a ceiling. All of that made the statute constitutional.
Well, what about this problem of the FCC handing off some of this responsibility and decision-making to a private entity?
The Supreme Court addressed that as well. After addressing the constitutional non-delegation, it turned to the private non-delegation and said that the FCC retained control and approval over the ultimate determination of what the Universal Service Fund would be. So while this administrator entity calculated it based on factors that the FCC had approved in terms of what services would be provided. It calculated it based on inputs from telecommunications providers as to what their revenue would be. And ultimately, the FCC had the power to approve or not approve it and oversee the process. The Supreme Court said that was enough to prevent it from being an improper delegation from the FCC to the administrator.
I think it's fair to say, Zhonette, that NCLA was mainly disappointed in the outcome of this decision because it didn't do anything to reinvigorate the non-delegation doctrine. But were there any positives in the decision from your perspective?
From my perspective, there were a few positives in the decision. Part of our brief that we had submitted as an amicus talked about what I call the intelligible principle fallacy. This stems from a Supreme Court opinion, American Power and Light, that tried to distill the prior non-delegation precedent to say so long as Congress provides an intelligible principle, then that's all that's required. It then, in that case, the Supreme Court went on and said, well, look, we found things like just and reasonable rates and in the public interest to be a sufficient intelligible principle, so that's good enough.
Almost sounds like anything goes.
It does. Well, that's what the court made it sound like there, and that idea of in the public interest is enough, because that is so unconstrained, threw open the doors to what is sufficient to find an intelligible principle. And so our brief argued there is no such thing as public interest being in and of itself a sufficient intelligible principle. We went through the history of the cases and how that was, number one, dicta when the Supreme Court said it, and number two, wrong, because in every cited case there was more at issue. So one of the glimmers of hope is the fact that repeatedly in the opinion when the Supreme Court addressed public interest, they then went out of their way to say, but there's always been more. There have been other things, there have been this history, there have been, et cetera. And we said that back in this other case, not so much here. But for example, in the public interest has never meant just general public welfare. So that's one issue that was good. Another issue that was good.
It sounds like the court might have read your brief.
Well, I certainly hope so. I anticipate that they did. Another thing that was good that we've talked about briefly here was the requirement for judiciable standards. And so in this particular instance, when the court was reciting the intelligible principle doctrine, which normally just consists of a policy and boundaries, the court did add into that discussion and equation the requirement for standards, judicial standards, that the public and the court can determine whether or not the agency has gone too far. So,
and here, when you say justiciable, you don't mean in the sense of justiciability, the sense that, well, this is something the court doesn't have the capacity to address. You mean that, in fact, that it has to have standards that would allow a court to pass judgment over it.
Essentially, it has to be something discernible, something that is not subjective and in the eye of the beholder, so that if, for example, the FCC says, yeah, that's good enough, that looks like that's sufficient.
Close enough for government work.
Right.
Yeah.
The court found sufficient has, upper and lower limits. And so that's what I mean when I say justiciable standards. It has to be something that you can look at, and there is a right and a wrong answer. I think that one more positive of the case is a footnote where the court said, it's possible that these two elements relating to the hospitals, libraries, and schools, these two elements may be problematic, but the parties didn't really address it, so we don't have to deal with that. I think that those two principles and that recognition, I think that goes to the idea that boundaries aren't enough, that there actually do have to be standards. And I think that if the case had been argued to really identify where there are gaps in the boundaries, that the FCC can get through anything that it wants in terms of funding, I think that it could have had a slightly different bent to the opinion. And so I think if that footnote where the court admits there may be a problem here, but we don't have to address it, I think that's helpful as well. And the court specifically used, and I like the use of metes and bounds, not boundaries, because a boundary could be on one side or two sides. Metes and bounds means the power is fully constrained all the way around. A metes and bounds description of the property goes from point to point to point, and the land, the property, the discretion is fully locked in. I think that's important.
Other than what the court failed to do here on the non-delegation doctrine, were there any other negative aspects to the decision?
Yeah, I think that the court has hailed back to a very sort of squishy test. As I said, judiciable standards, standards that a court or a public can say, okay, is there a right or wrong? The court's test here essentially said, well, context matters, and the more power Congress gives, the more direction they have to give. And the more sort of important the issue is, the more direction they have to give. That's very, very dangerous. And that does rather leave things in an eye of the beholder, with the beholder now being the court, to determine when does the non-delegation doctrine apply and at what level. We don't even have intermediate, various levels of scrutiny. We have some sort of sliding scale that's completely undefined now. And the court talked about it one way in terms of regulating the entire economy. The dissent talked about it another way. So I think the squishiness of the test and that associated idea that there are important rights, that somehow a constitutional violation is more palpable when fewer people are affected, when there are less dollars at issue. I think that we should strongly reject that notion, because that goes completely against the idea of individual rights and the protection of the minority that the Constitution supported.
Zhonette, did the demise of the Chevron deference doctrine and the court's decision last year in Loper Bright and Relentless have an impact on what happened here?
It did have an impact, and I wish the court would have been a little bit more forthcoming, I think, about that impact. As I mentioned, the court's interpretation of the statute here is different from what the agency has been advocating for the last 20 years. The statute's been in place since 1996. And the court's interpretation here doesn't align with what lower courts had found. So post-Loper-Bright and Relentless, the courts, and courts should, feel free to do their job and interpret a statute de novo, determining what the law is and what the statute means, not beholden to an agency's prior interpretation. I think that was very much in play here when the court seized upon an interpretation that hadn't been previously adopted by the agency or the courts.
Zhonette, I take it you would have been happier with the dissent penned by Justices Alito, Thomas, and Gorsuch. What did they have to say?
Well, obviously, they felt that the statute issue here was unconstitutional, and particularly that the delegation from Congress to the agency was not constitutional. They focused on the fact that it is, whether you call it a tax or anything else, it's the equivalent of a tax. And as the saying goes in law, the power to tax is the power to destroy.
I think the court itself said that in, McCulloch v. Maryland, if I remember correctly.
Exactly, and people have seized on to that. And the Constitution gives the taxing power explicitly and only to the legislative branch. And so the dissent said, yeah, context matters. And in this context, we're talking about a taxing power here. We're talking about, they went through the history of how, yes, a universal service fund idea has been around since the funding of the FCC, but not this idea.
And not one this big. I mean, this is larger than the annual appropriation that Congress gives to the FCC.
Well, yes, the program has ballooned incredibly. But the FCC, communications, all of this used to be more heavily regulated, and there was a monopoly. This all stems from the Ma Bell days, when an agency or when a company like Ma Bell is a regulated entity, you don't have to give as much direction. You're approving their rates. And so it's a completely different concept of what is sufficient to guide that entity and to guide the agency that's overseeing the entity. So they called attention to that, and they would have held it, like I said, they would have held it unconstitutional. And I think in contrast to the majority saying, it's not like this regulates the entire economy. Gorsuch and the dissent agreed that context matters, but they would have given discretion for something like designing a tax stamp as opposed to, determining how much money to take out of the pockets of American consumers.
So Justice Kavanaugh's concurrence has gotten a lot of attention in this case because of what he said about the major questions doctrine. But maybe we can come back to that. But what did he say overall? And then let's come back to the major questions doctrine aspect of it.
Yeah, Justice Kavanaugh essentially tried to, I think, calm the people who would be concerned about this decision, given the breadth of the statute at issue, and said he had two parts to his opinion. The first part essentially recounted the usefulness and purpose of the intelligible principle holding and precedent, and how it gives flexibility to the executive, and how it prevents the judiciary from improperly interfering with the executive carrying out the law. And so that was the first part of his opinion. The second part of his opinion sort of broke down the context, and that's where he talked about the sort of major questions. He talked about the fact that there's different limits if we're talking about foreign powers versus domestic powers, that sort of thing. But it was the first part of the opinion was very sort of executive power focused discussion, calling on Rehnquist and Taft and Scalia, people who had previously spent time
like Kavanaugh
in the executive branch. Yes, and so that was a bit alarming.
Most troubling to me, Zhonette, Justice Kavanaugh suggests in this concurrence that maybe a robust non-delegation doctrine isn't necessary in a world in which the major questions doctrine exists. Can you expand on what he said there and explain maybe what he had in mind? Because from my perspective, the non-delegation doctrine and the major questions doctrine do two different things.
Yes, I don't agree with where he landed, but my understanding of his argument essentially is when you apply the major questions doctrine, the question, you only apply it when there are major issues of major economic and cultural differences at issue. And
it's a kind of clear statement principle, right?
Well, it is a clear statement principle, but yeah, the clear statement essentially is, did Congress give that power? It's almost like a precursor to the non-delegation doctrine, because it is, did they give that power? If the answer is no, and the major questions doctrine requires a clear statement if there's a lot of power at issue.
Right.
So if the answer is Congress didn't give the power, you don't have to worry about non-delegation.
But that's only half of the question. The question is, well, what if Congress did give the power and they did it clearly? It doesn't mean that they were allowed to.
That's correct. And once you've cleared the major questions doctrine and you determine that Congress actually gave the power, that's where the problem is. So but that's only part of the problem. As I discussed before, that's very dangerous in the idea that we should be satisfied with knocking out important questions and leaving Congress and the agencies to incrementally peel off certain industries, certain subsectors of certain industries, and we're not going to apply the major questions doctrine there because it's not big enough to worry about. And so you get slipped through that and you're stuck with this, death knell version of the intelligible principle. So that's just not at all satisfying.
Well, in Article 1, Section 1 says all legislative power, not just legislative power over major questions.
Right. Well, and that's part of the problem with today's version of the intelligible principle. There are courts of appeals who have literally said that Congress can give legislative power so long as it provides an intelligible principle. That is completely inconsistent with the Constitution. Either what Congress did is enough to prevent it from being legislative power, or it's unconstitutional. But when you have courts flat out saying that Congress can transfer legislative power, there's something wrong with the constitutional doctrine.
Given this discussion, Zhonette, what impact will the court's decision have going forward?
Well, I think it prevents a bit of an opportunity to focus again on the standards. And that's the optimistic side of what it may do. The pessimistic side is the court does not take non-delegation cases very often. And so there's a concern that because it has taken this case and given this ruling, that it won't take another non-delegation case for a while. I think that's not necessarily correct, because this idea that they've opened up, this sliding scale of context matters, I think that's going to present problems. I think the agencies are going to seize onto that. They're going to focus on, and I've seen them focus on, the idea that, well, it's okay to leave technical issues without much direction to the agency. And so now all of a sudden everything's going to be a technical issue. So I think that there are opportunities on both sides, and those opportunities on both sides to argue for a stronger non-delegation doctrine or to argue for a looser intelligible principle, they're going to find their way back to the Supreme Court.
Turning now to the D.C. Circuit's decision in Choice Refrigerants, Zhonette, the timing of the release of that decision suggests that they were waiting for the court's decision in the FCC case. As it turns out, they didn't need to wait because not a whole lot changed. But what did the D.C. Circuit ultimately decide in the Choice Refrigerants case?
Sure. Choice Refrigerants was about whether the EPA now has too much power such that it was legislating, and particularly as it related to a cap-and-trade program for refrigerants. And essentially what the D.C. Circuit held was, no, that statute is fine, because what the D.C. Circuit did was pick up on other statutes. The D.C. Circuit, unlike the FCC case, the D.C. Circuit didn't resolve that question by looking at the statute at issue, which was called the AIM Act. The D.C. Circuit took a standard, an intelligible principle, from a different set of statutes and said, well, Congress meant for that to apply. And so
it must have meant for that to apply. Yeah.
Exactly. So that's all fine. So the D.C. Circuit rejected our petition on behalf of Choice Refrigerants to challenge the EPA rule that set the phase down for these refrigerant products.
Zhonette, can you explain the non-delegation issue lurking in the case and how the court's decision really dodged it?
Absolutely. So as I think I mentioned, the issue regards refrigerants, and for a certain type of refrigerants, the AIM Act creates a cap-and-trade program. So over time, the market for those refrigerants has to shrink 85% from what the prior usage was, down to 15%. And so Congress said, here's levels by which the amount of this refrigerant use needs to decrease in certain years The EPA create a cap and trade program that makes sure we have enough refrigerants for these uses primarily, and then hits the caps or doesn't exceed the caps in any given year. The problem is Congress didn't tell EPA how to allocate the market that it had now given EPA control over. So the market is now controlled by EPA through the issuance of these allowances. That takes away, in our case, our clients' right to do business the way they had been doing it. And not only
Our
that,
client who invented the refrigerant issue.
one of the refrigerants that they sell,
Yeah.
absolutely, and who reclaims other refrigerants to better the environment. And so our client ultimately, due to various machinations of the EPA, and because the EPA literally took a part of the market and set it aside for new entrants, our client's market share was artificially decreased, even taking into account the ratchet down and the phase down under the AIM Act.
But that's not what happened in the Clean Air Act. So how can the court point to the Clean Air Act to justify setting aside something for new market entrants?
Well, what the court was specifically pointing to was the statutes regulating ozone-depleting substances. So there was not a phase down, but a phase out of ozone-depleting substances through sort of a cap-and-trade program that Congress created. In that statute, though, Congress was explicit that the phase down was according to the market share of the people who were then in the market. They didn't say anything like that in the AIM Act. They brought in other elements from the Clean Air Act, from that title, that provision of the Clean Air Act, but they did not. Congress did not say to EPA, thou shalt give allowances according to market share. Even if they would have said that, there's a lot of discretion in determining how to figure out what market share is. But like I said,
So why does that matter that they didn't say?
because of what the EPA did here. The EPA looked at the ozone-depleting substances statute, said, we don't have to follow that because that was a phase out, this is a phase down, this market's going to continue, so we can apportion the market however we like. And so, for example, they created different types of allowances. So if you're in one part of the market, you get a certain type of allowances. And if you provide certain products, you get a certain priority on allowances. Then they took this set aside of part of the market to give to new market entrants. Then they gave out what they call the rest of the general pool according to market share. Well, that took business away from our client who has a patent on some of these products. The EPA did other things like giving some of our clients' market share to intellectual property pirates. They allocated market share according to who imported the product rather than who actually had the patent on the product and had the market for the product. They did a lot of things that hurt specific small businesses in particular. And so that's why it matters. And you're taking a private industry essentially and making it into a planned economy.
So Zhonette, given all of this, what happens next with Choice Refrigerants? What are the next steps you anticipate taking in the case?
Well, I don't think the D.C. Circuit's interpretation of the AIM Act is correct. I think that they were wrong to take these pieces of the prior statutes and just incorporate them into the AIM Act. But that problem was exacerbated by the fact that the D.C. Circuit mischaracterized how the EPA had actually issued allowances and said that the EPA had issued allowances according to market share. They hadn't.
Yeah, they essentially upheld something that wasn't what happened.
Exactly, exactly. And so our first approach to this is going to be, we're going to seek a rehearing because the D.C. Circuit got the facts wrong, the D.C. Circuit got the law wrong, and even if you accept the D.C. Circuit's interpretation of the AIM Act, which I think is wrong, that creates problems that should not have led to them sort of blessing the program as it has moved forward, because the program as it has moved forward is contrary now to how the D.C. Circuit has interpreted the statute. So they have to reckon with the consequences of getting both the facts and the law wrong in a way that created inconsistencies.
Thank you very much, Zhonette. That was a very interesting and enlightening discussion. I think you've raised several questions that merit further consideration. I know for NCLA's part, we will continue to bring these kinds of non-delegation cases to the Supreme Court. and the D.C. Circuit for that matter. You can lead the justices to water, but you can't make them drink. Perhaps your D.C. Circuit case will be the next one that's a non-delegation case to reach the Supreme Court. Thank you for watching Courtside Commentary.